At first glance, the defense makes a compelling argument: family support, a potential job, and claims that he's not a flight risk. But here's what really matters in a bond hearing. The judge isn't deciding guilt or innocence. The court is weighing public safety, criminal history, and whether the defendant is likely to return. Do you think financial hardship alone should justify a lower bond? Let us know in the comment.
Good morning. Are you Micah Powell?
Yes, ma'am, I am. Good morning.
And this is cause number 25 DCCR 1522. Mr. Powell is charged with burglary of a habitation. Mr. Minaldi is here on behalf of Mr. Galmore, who filed an application for writ seeking reasonable bail. Looks like the bond is currently set at $50,000. Ms. Minaldi, you may proceed.
Judge, just based off of Mr. Galmore's request, it's clear that with his family having an interest in his case and supporting him in that case, he would be here for court settings if he were to be released on bond. He does have the proper means to get to his attorney's office. He does have the proper means to get him to court. He has motivation to show up and handle these cases. He's not a flight risk. He's not at risk of not showing up in that capacity. We're just requesting that he have a bond set that he can afford. I believe Mr. Galmore has requested it be decreased to $5,000 so that he can afford it. It's clear that he cannot afford the current amount of $50,000.
Let's put some evidence on with regard to that. Raise your right hand, please, sir, the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do.
Thank you. Go ahead.
Do you have access to any type of savings accounts in your name?
Yes, I have. I have 2 different bank accounts.
Okay, where are those bank accounts?
Ready Financial and
That ruling probably surprised some viewers. The judge didn't just deny the request. She actually suggested the existing $50,000 bond might already be too low considering the allegations and criminal record. In Texas, habitual offender status carries enormous weight during bond decisions because judges have to balance the defendant's rights against community safety. That's a reminder that past convictions can dramatically influence what happens long before a trial ever begins.
Ready Unit out of Galveston. Can't remember the exact name of it.
And about how much do you have in those accounts?
About maybe 901, and the other one was probably maybe I had one of them was for withdrawals. Probably about 1,400 total.
Okay, and are you employed currently?
Due to my incarceration, I am no longer employed, but I do have somebody willing to take a chance on me and give me a very good job opportunity for release.
Okay, and is that job located in Jefferson County?
It would be over in Pasadena.
But
I can drive back.
You would be able to come into your court settings?
I am looking to get this settled because I cannot go on my life with this over my head.
And then do you have any type of cash or any money outside of those savings accounts that you mentioned?
I do hand over fish and guide services for anybody who requested to give me supplemental income.
But do you have any actual physical cash that is supplement to those savings accounts that you mentioned?
No, I'm not currently.
Okay. Do you have any assets, stocks, bonds, or anything like that that you could access to help make the current bond? And then do you own any real property?
Any questions?
There's not argument.
All right, go ahead, Ms. Malfino.
Judge, I would respectfully object to the bond being reduced, especially to an amount of $5,000 for a habitual offender who has prior burglaries for which he has served pen time. This will be a pen time offer in this case. I believe the offer extended by Mr. Smith actually went below the minimum 25 of his habitual status, but we don't think that any bond lower than $50,000 is justified, judge, based on his criminal history, and would ask the court to take all of that into consideration.
So I am going to take judicial note of the court's file. You need a drink? You good? Including obviously the indictment itself that alleges prior convictions, burglary of a habitation.
This is one of those courtroom moments that often gets overlooked. Even with a trial date approaching, negotiations can continue until the very last minute. Prosecutors and defense attorneys frequently ask for extra time when they believe a plea agreement could avoid a lengthy trial. Sometimes one conversation is all it takes to completely change the outcome of a case.
Second-degree felony from the year 2000, two different ones from that same year. An evading arrest or detention, third degree from 2007. Another burglary of a habitation, a second degree from 2018. Looks like all of those, well, we've got Galveston County, Tyler County, and Harris County alleged, and Jefferson County. So I also have reviewed the probable cause affidavit in this case, and the allegations in this case looks like, at least according to this, that the allegations are that Mr. Powell was actually trespass warned from the owner of the house's job, that there was some type of harassment in the past or some relationship that caused some issues where he was actually trespass warned from a job location, and that there is apparently video footage of this offense as well. Based on all of that and the fact that he would be considered a habitual offender, with this being his fourth allegation of burglary of a habitation, if anything, that bond, in my opinion, is low. Based on all of that, I'm going to deny the writ and find that, or the request based in that writ, and find that the current bond is sufficient, I guess. I don't really think it is, in fact, but I'm going to keep it at least the same for now. All right. And we'll reset it for an announcement. You can go back with the bailiff.
Thank you, Judge. May I have the excuse?
Yes, ma'am. Thank you. It was 50 or 20?
It was 50, Judge.
Okay. Thanks. Ms. Minaldi, I'm also, just in case it wasn't already, I'm sure it's a condition of the bond, but I am, if you'll let him know, going to make sure, if it's not a condition of that bond, that he have obviously no contact or communication with the complaining witness, and also that he is not allowed to live with the friend that lives across the street from her.
Okay.
Okay.
And I'll make
Can't be anywhere near the house or job.
Okay.
Okay.
Thank
Thank
Judge.
you. And I'll make that notation on the order, and you guys will, it'll be filed, and you'll see
Okay.
it later.
Thank you, Judge.
Mr. Kelly, are you ready on Dalton Batiste?
Your question? Thank you.
Notice how quickly this plea hearing moved. That's because every required legal step had already been completed before entering the courtroom. The judge confirmed the plea was voluntary, verified competency, accepted the agreement, and imposed the negotiated sentence. It's a reminder that what looks like just a few minutes in court often represents weeks, or even months, of legal preparation behind the scenes.
Right, sir, are you Dalton Batiste?
Yes, ma'am.
And this is cause number 25 DCCR 1436. Mr. Batiste is charged with manslaughter. 25 DCCR 1437 charged with manslaughter, and 24 DCCR 0407 charged with possession of marijuana. The cases are set for trial to begin with jury selection next Monday. And what is the announcement?
Couple issues, if I may, Judge. Mr. Coleman and I have talked extensively, not only this morning, but in the last lead up to today, and there has been a new proposal put in front of us that I think we'd like to ask for at least a little bit longer than today to consider. I know that also Mr. Coleman has responsibilities to folks on his side to discuss it. Court will require to decide this. Sorry,
Take a break. Why is this one? This one's not showing up on my. It's not on my.
Actually, Angel has his trying to get Tony. He was being very difficult. But now it says Tom Kelly, so that's why we included.
Oh,
Because I had changed their co-counsel and he was trying, I thought he was signing them up. Wanted to make him really turn.
okay.
Now the stakes become incredibly serious. Because of the defendant's prior felony convictions, prosecutors are seeking punishment under Texas habitual offender laws. That means the sentencing range jumps dramatically. This isn't just another criminal case anymore. It's one where a single decision could determine decades of someone's life.
couldn't walk the tablet.
And then
You okay? You need some water?
I've got.
you want cough drop?
Oh, I do have that.
I think the sinus is the best.
Yeah. Yeah.
No, it's fine. Well, okay, so here's the thing. There's only 2 defendants left on the trial docket for next week. So I need to know something today.
My other issue, Mr. Gertz asked me to say this. He is set in Judge Templeton's court
Oh,
on a case, Austin
Yes,
Jones.
especially if
Been
that,
tried previously too.
and that's next week.
That's next week.
Yeah, I'm not sure that I should have taken that into consideration. So obviously that is a specially set case for Mr. Gertz over there. And we've done a protection order for him to get that case taken care of since it's an injury to a
I
child.
understood, Judge. I think we're very close to resolving this case. Still, notwithstanding the other case, I
Okay.
still would like to try to push this case to get resolved.
Sure. So here's what I'm
I can
gonna
talk to my
do.
victims.
So what I'm gonna do is just for a short time, take it off the trial docket, place it on a review in about 3 weeks. That gives you and Mr. Gertz time to visit with Mr. Batiste, Mr. Pullman time to visit with anybody he needs to visit with. And then if something gets worked out, we'll take care of it at that time in 3 weeks. If not, it'll go right back on the trial docket and we'll go from there.
Understood.
Sound good?
Yes, Judge.
Okay, you can go back with the bailiff.
Thank you. Thank you.
Yes.
Hey, Ms. Holmes, you've got Jacoby Frazier.
Yes, Your Honor.
I was in the midst of signing him up. However, out of an abundance of caution, I think he needs to be evaluated.
Is that the one that was out here?
Yes.
Yes. So we'll reset Mr. Frazier and you can just do our order. We'll get an evaluation order today. Darius Derry.
And here's the twist many people miss. By rejecting today's plea offer, the defendant isn't just choosing a trial. He's also walking away from an offer that may never return. Prosecutors often make today-only deals, and once they're gone, they're gone. Was taking that risk the right move, or should he have accepted the reduced sentence? Share your opinion below, because this is exactly the kind of decision that can completely change the course of a case.
Thank you, ma'am.
Here you go. Yeah, yeah.